The committee will come to order. The chairman notes the presence of a quorum, which under Committee Rule 3E is 2 members. The Subcommittee on Energy and Mineral Resources is meeting today to hear testimony on an oversight hearing titled Implementation and Administration of the 2013 Helium Stewardship Act. Under Committee Rule 4F, opening statements are limited to the chairman and ranking member of the subcommittee. However, I ask unanimous consent to include any other members' opening statements in the hearing record if submitted to the clerk by close of business today. Hearing no objection, so ordered. I now recognize myself for 5 minutes. I'd like to thank our witnesses for being here today. The subcommittee is meeting for an oversight hearing on the implementation and administration of the 2013 Helium Stewardship Act. Today we will hear testimony regarding BLM's implementation of the Helium Stewardship Act of 2013. This bipartisan, bicameral legislation was signed into law by the President in October and for the first time injects free market reforms to the sale of helium from the Federal Helium Reserve. It also increases transparency and ensures the temporary continued operation of the reserve before scheduling the final closure in 2021. All this while providing American taxpayers with a fairer return on this valuable public resource. And it goes without saying, helium is used for a lot more than party balloons. It's used in high-tech manufacturing, it's used in defense technology, it's used in medical research, MRIs, and things like that that are critical for our economy as we have it today. We have all been waiting for the BLM to release the final helium notice of sale in preparation for the planned helium auction at the end of the month. This sale notice, which replaces the formal drafting of regulations due to the short time period necessary to meet the timeframes mandated in the legislation, reflects BLM's consideration of guidance from numerous stakeholders, as well as multiple meetings with bipartisan House and Senate committee staff. The goal of the Helium Stewardship Act is to ensure that taxpayers receive a fair value for this federal resource and to create a free market for federal helium sales. This is a change to the status quo of the BLM selling cheap helium to a small handful of exclusive purchasers without competition, resulting in taxpayers missing out on millions of dollars over the last decade. BLM has a number of challenges. The primary challenge is breaking the hold that helium refiners located along the pipeline have had on access to the helium reserve. For more than a decade, BLM has actively worked with the helium refiners to deny access to the pipeline and eliminate competition for federal helium. This has allowed a small handful of refiners to limit access, depress prices, and stifle competition. The Helium Stewardship Act requires BLM to eliminate this collusion between themselves and the refiners by requiring refiners to report to the BLM any excess refining capacity in their refinery, and enforcing the mechanism in the Act requiring refiners to toll federal helium for other purchasers at commercially reasonable rates. If helium refiners inaccurately report their excess refining capacity or offer tolling at exorbitantly high rates, the law requires the BLM to withhold helium from any refiner or prohibit their participation in the auction. This is what the law says. This is the primary mechanism agreed to, and I expect to hear in BLM's testimony today that they will actively enforce this mechanism by clearly prohibiting refiners who continue to game the system from purchasing helium if they do not obey the law. Failure by BLM to actively engage and enforce the law will have purchasers of crude helium without the security they must have when they purchase helium from the BLM. There must be firm assurances that purchasers will have access to the appropriate pipeline capacity to deliver that helium. I look forward to hearing BLM's plan to ensure that all purchasers of helium will have access to sufficient pipeline capacity to transport that helium, and that these purchasers will not be left waiting years to move their helium from the reserve to market due to uncompetitive actions of the refiners. Finally, BLM's successful implementation of this law will be measured by the amount of competition in the helium sale, the helium price, and the ability by non-refiners to process and toll their purchased helium. I appreciate the BLM and the GAO being here to testify for us today, and I look forward to hearing their answers to several questions our subcommittee has regarding effective implementation of the Helium Stewardship Act. I now recognize myself. Ms. Lance, I want to ask you about BLM's willingness and preparation to ensure that tolling will be available to non-refiners who purchase helium. The Act states that in order to receive any allotment of helium from the BLM, refiners must make, quote, refining capacity of helium available at commercially reasonable rates to, unquote, purchasers of helium. Failure by a refiner to make such capacity available at reasonable rates is clear grounds for BLM to deny that refiner access to future allotment volumes or participation in the auction. Can you explain to the committee clearly what steps BLM is taking to ensure that refiners are complying with the law and what you have discovered with regards to establishing a standard for commercially reasonable rates?
Thank you, Mr. Chairman. As you know, this is a new provision that we're implementing for the first time, and we do see our work in this area as an iterative process. And we expect to learn from each auction that we hold ways in which we can improve the process. What we have done since we held the Phase A sale is to publish a proposed notice that will govern the 2014 sales, and that defines excess refining capacity. We've also put up on the web a number of reporting forms that we had not had available in the Phase A sale, and that will be required prior to the Phase B sales. That will also move forward in helping us gather the information from the refiners that the statute requires. Let me just say clearly that we understand clearly our obligation to enforce this provision in the law and to make sure that we do have this information available. If we aren't able to get it, we understand that the lever that we are expected to put into play is to deny those refiners the ability to participate in the sales going forward. We hope not to get to that point. We hope to be able to work well with all the parties involved going forward so that we can get the information that we need and make sure that the non-refiners do have the ability to have their helium refined.
And do you agree that it's critical for non-refiners to know up front that they will have access to tolling at commercially reasonable rates so that they'll participate?
That's how we read the statute, yes.
Okay. And is it reasonable to ask the non-refiners, would it be reasonable to ask non-refiners to participate if they just had to take someone's word that they would have the ability to toll after and purchase at a reasonable rate at some point in the future?
Well, I think our opinion on that is probably less relevant than the requirements of the statute and what Congress has directed us to do. And so we're proceeding on that basis.
And Ms. Fennell, you have highlighted this area as one of the primary challenges facing BLM. And having heard from BLM what their thoughts are, do you believe that they are taking the necessary steps?
I believe that they're taking some initial steps.
Could you pull that just a little closer? Thank you.
I believe that they're taking some good initial steps in terms of defining what the excess capacity is. On the form, they've attempted to do so, but there are still some opportunities for interpretation, and so it'll be very important to see once those forms are completed, what type of information is actually provided and how the different refiners are actually interpreting the definitions that are specified on the form. We do plan to take a look at that once the auction has occurred and the information is collected and aggregated.
Okay, thank you. And Ms. Lance, the Helium Stewardship Act requires the BLM to ban a company from participating in the auction if they are not accurately reporting excess capacity or if they are not offering commercially reasonable rates for tolling. Will the BM follow the law and prohibit a company from participating in the auction if they violate one of these provisions of the law as well?
Mr. Chairman, we will follow the law as we've been directed to do.
All right, thank you very much. I have more questions, but I'll save them for the next round. And at this point, I'd like to recognize Representative Holt. This is an important issue. Let's have a second round of questions. Ms. Lance, ensuring the accuracy of reporting excess capacity is one of the key components of the success of the Helium Stewardship Act. If refiners do not accurately report excess capacity and consistently do so, other auction participants will not have an accurate idea of how much capacity is available to refine the pipeline, and this uncertainty may discourage some buyers from participating. What safeguards does BLM have in place to ensure the excess refining capacity that is being reported is accurate and consistent? And what specific steps will you take to hold refiners accountable to ensure that they are correctly reporting this capacity?
Well, as we've discussed, we have now defined excess refining capacity and created forms that will require that reporting. And the statute does require as well that we receive information on refining capacity from the refiners. Generally, we have access to more general information, and as you know, some of that information is business confidential for the individual refiner and not made public. In fact, the statute goes out of its way to protect the confidentiality of that information. But we do have aggregate information that is public and that we're aware of, and so we are able to, our experts who work on this are able to form some expert opinion about what the excess refining capacity may be, and we're in a position to review the information that we receive and apply our expertise to that information.
You know, we've been discussing this issue a lot today, and Ms. Fennell has brought it up as well. Could we just define excess capacity as the difference between the volume delivered to a refiner when the reserve was producing at full volume and the volume being delivered today?
Well, we do have a definition in our notice, and I'd need to compare it to that. Of course, we'll have a definition carrying forward into our final notice, but I'd be happy to consider that as we go forward. And Mr. Spisak may have something in addition, additional thoughts on that?
Certainly. The issue that's more difficult now is when we were talking about excess capacity, it was often referred to how much installed capacity there is along the pipeline, and that's over 2 billion cubic feet of refining capacity if you look at all the plants. But a more important number is the effective capacity. That is the amount that the system can produce, and then how much refining capacity and how that matches up. And with the drawdown in the field, as the physics asserts itself and the pressure and such lowers the amount that the system can produce, there's always an excess capacity of refining there. But if there's not enough for the system to get to those plants, then it becomes that's where the rub is. That's where we have to figure out how to apportion that in such a way that you have an opportunity for non-refiners to be able to have some kind of certainty that if they buy some helium, that they'll be able to get that helium refined. So that's kind of the challenge that we're working through.
Okay, thank you. And Ms. Fennell, could you comment on this from your perspective of the GAO?
We've noted that BLM has been working through different iterations and definitions, and I think definitions are going to be very important going forward. For example, one iteration talked about planned demand, but in talking to different companies, that can be defined in different ways. For example, it could be considered what is already under contract versus what's projected to be under contract. And so I think going forward, it will be very important to see how the refiners also interpret the definition that is put forward and what type of information BLM receives from them.
And you would agree that it is important to have whatever the precise parameters and outlines of a definition, it needs to be consistent as well as accurately made and enforced to be accurate, but it has to be consistent among refiners. Isn't that of utmost importance?
Yes, I would agree that it would be important, and that's also something we'll continue to look at as we continue our review going forward.
Okay, thank you. Representative Holt.